It is my honor to be able to introduce law professor and former dean of Harvard Law School, Martha Minow. Martha is a respected legal scholar with expertise in advocacy for members of racial and religious minorities, war refugees, persons with disabilities, and the poor. She is also the vice chair of the Pro Bono Task Force. Formerly, the vice chair of the Pro Bono Task Force of Legal Services Corporation. Her new book, When Should Law Forgive, explores the relationship between law and forgiveness. It is a compassionate examination of when it is appropriate for legal institutions to press for mercy rather than punishment. She discusses legal treatments in regards to corporate and student debt, different outcomes for juvenile offenders in the U.S., child soldiers in international courts, and various other contemporary issues. Kirkus Reviews praised When Should Law Forgive as a, quote, a solid, accessible contribution to the literature of restorative justice, end quote. Everyone, please join me in welcoming Martha Minow.
Good afternoon, and thanks for being here. Thank you, Sly. That was really lovely. I am not a forgiving person, maybe because I drive in Boston. I don't know. There are lots of reasons. But we had an amazing moment in this country this week, just a few days ago, when a young man named Brant Jean, at the end of the trial and the sentencing of police offender Amber Geiger, who had shot and killed Brant's brother. On the mistaken view, she defended herself that she thought it was her own apartment. In any case, Brant said spontaneously to the defendant, "I forgive you." And I can't imagine doing that. I think that is an extraordinary act of grace. I also think it's notable that it reminds me of the moment after Dylan Roof's arraignment, when he shot 9 people who were at Bible study at Mother Emanuel Church. Again, there were members of the congregation who said, "I forgive you." It's interesting and I think noteworthy that in both instances, the people who were giving the forgiveness were African American. And I think there's some very telling and important questions. Who's expected to forgive and who's not expected to forgive? And I think there are gender and racial and other structural explanations often. And yet, at the same time, I don't want any of us to underplay the power of forgiving, the power that victims have to give and also to withhold forgiveness. And I was really interested in this subject some time ago, but particularly interested at a societal level. After we have a civil war or a mass conflict, is there a way for a society as a whole to move ahead? So a while ago, I wrote a book called Between Vengeance and Forgiveness, and I compared the ways different societies have responded to mass atrocity, whether with criminal prosecutions, as in the Nuremberg trials, or with the Truth and Reconciliation Commission in South Africa, or reparations, or with uses of art. And I wrote the book and I, struggled with it, and I called it Between Vengeance and Forgiveness because I thought law can offer an avenue between these two alternatives. And I'll tell you, ever since, people have said to me, why not forgiveness itself? Can't the legal system either encourage people to forgive or the legal system be more forgiving? So I thought about that, and somewhere in the middle of it, I became a dean. And really not very forgiving during that experience, but most significantly for the purposes of this book, that affected me in leading me to think about debt and the different kind of forgiveness that debt involves. And why? Well, it turns out law school was in debt. The students were all in debt. We're all dealing with debt all the time. And it's not by accident that we use the same word. We use forgiveness. And so I decided to write this book. And the book actually explores when, if ever, the legal system itself should forgive, and by that I mean let go of a rightful grievance. And when, if ever, the legal system should encourage or at least not discourage people from being forgiving. So did you know that there are 36 states now that have what are called apology laws? And these are laws that don't ask people to forgive or apologize. What they do is they remove the legal liability that happens when, for example, a medical professional says, "I'm so sorry," to a patient, with the fear that that very statement could be introduced into a later malpractice action or a civil action or what have you. And so these apology laws say those statements cannot be introduced in a later legal action. I think that that's at a minimum what law can do. It can make it not a liability to express the human sentiment of compassion and concern and, yes, apology and maybe forgiveness. But I think there may also be occasions where law itself should forgive. And so when I say forgiveness is letting go of a rightful basis for a grievance, we are about the most resentful country in history. And I say as evidence of that, we're the most incarcerating nation in the history of the planet. There is no society that has ever locked as many people up as we do right now. And that seems to me an expression of too much resentment and not enough forgiveness. And yet it's also ironic or telling to me that the legal system, our system, other systems build in mechanisms for forgiveness, quite apart from whether they encourage or discourage individuals to forgive. So an obvious one is a pardon. A president and executive can pardon someone who has been charged with a crime, has been convicted, any point in the process. But there are other elements of a formal legal system that involve forgiveness, that include even a police officer deciding to say, "I let you go," or a prosecutor deciding, "I'm not going to prosecute you," or "I'm not going to prosecute the class of nonviolent drug offenses." That's a kind of forgiveness. That's letting go of otherwise available legal sanction. We don't, however, have a way to think about it. I'll tell you, I've been teaching in a law school almost 40 years. We don't teach about this. We don't have a jurisprudence of forgiveness. We don't develop criteria for when should a pardon be given or, may I say, not be given. We don't have ways to even evaluate when a sentence in one case is justifiable as opposed to another. And so that's really the occasion for the book. And one of the techniques that lawyers use to try to learn something and develop insights is comparison. So the book is structured around two central comparisons, criminal law and bankruptcy. Bankruptcy as a technique developed by law to deal with a kind of blame, right? A kind of warranted grievance. Someone has promised to pay back a loan and doesn't pay it back. Well, since the 11th century, there have developed techniques to deal with a debtor who can't pay. And bankruptcy is in the Constitution of the United States. Thomas Jefferson, a man who was in debt most of his life, understood very well why it might be justifiable and indeed important for the legal system to have a mechanism to forgive people's debts. And because he was Thomas Jefferson, of course, he had a political theory behind it. And his political theory was one generation should not burden the next with its debts. He failed on that score. He died indebted. But in any case, I think we can all be grateful to him because the authorization in the Constitution for a national statute to govern bankruptcy has led to a tradition in this country that is associated with the level of entrepreneurship, innovation, risk-taking, and business success. People come from all over the world to try to figure out why there's such a level of risk-taking in business that pays off. You know, I've talked to a lot of venture capitalists, and I'll tell you, some of them have actually said to me, "I won't back someone who hasn't failed already." There's an encouragement of risk-taking in that context. And the bankruptcy system that's developed, I think, has a very interesting feedback mechanism. Of course, someone declares bankruptcy, there's a sanction, there's a reputational effect, there's a credit rating effect. But by starting over, having a clean slate, people have a chance to start again. We don't do that so well when it comes to criminal law. So that's a central comparison. Criminal law in this country, even someone who has served their sentence in many parts of the country, then they face a lifelong barrier when it comes to seeking housing, seeking employment, seeking credit. In some places in the country, people lose the custody of their children. They can't obtain, or they will have to lose a license to engage in certain professions. And of course, many are barred from voting again. We are so punitive that even someone who has served their time continues to be punished. And that seems such a contrast with bankruptcy, where we say, yeah, there are going to be consequences, but you can start over. And we don't do that when it comes to crime. So that's a central comparison in the book. Another comparison in the book, though, within the area of crime, I was very struck, because I've done work internationally, by the way child soldiers are discussed in international law and politics. Sadly, all over the world where we have armed conflict, there is massive recruitment of juveniles, of minors, to become soldiers. Sometimes they're coerced, sometimes they're drugged. Oftentimes, they stay for quite some time. These are boys, these are girls. They often engage in horrific acts. And when there's peace, let's hope there's peace, what happens to them? Interestingly, the international criminal legal world has concluded the crime involved is the adults who recruited those young people. And the very first prosecution in the International Criminal Court of Thomas Lubanga actually found him liable for the crime of recruiting child soldiers. The question is, what about the children themselves? Or maybe they're now adults. And the answer is, it's somewhat left up to domestic law, but the view taken in the international criminal tribunals is they are not the most responsible. They should not be prosecuted. They should not be charged. And in many areas, for example, Sierra Leone, where there was a massive use of child soldiers, while there was authority in their international criminal court to do something about the juveniles, the prosecutor said, we're not doing it, because they are not the ones who should be centrally blamed. Compare that with the way we talk about juvenile offenders in the United States. We don't talk that way. We don't talk about who drew them in to the drug trade. We don't talk about, what's the larger pattern that has led to this kind of conduct. And here's an irony. The very same development of lightweight, cheap guns led to the increased use of child soldiers and the increased use of juveniles in the drug trade in this country. Isn't that ironic and bizarre and strange? So that's one contrast in the book, is to compare the treatment of child soldiers and the treatment of juvenile offenders, and to explore the possible uses of juvenile justice mechanisms, truth and reconciliation mechanisms. Not an easy question in either case. And I'll tell you, one of the very interesting developments I found in talking with people, talking with a couple of child soldiers and former child soldiers, and talking with people who work with them, is that the hardest issue is self-forgiveness for many of those young people, to forgive themselves for what they've done. Another comparison in the book in the area of debt is I compare the treatments of personal debt and business debt. So just as an example, student loans cannot be expunged in bankruptcy. But the for-profit companies that recruited young people to take out loans, and then the young people couldn't get the jobs, they can declare bankruptcy. That seems like not a very good result. What's wrong with this picture? I also compare the treatment of municipal debt and sovereign debt for states and for nations. It's very interestingly, a group of economists and lawyers tried to develop the notion of odious debt to explain that some debt of developing countries was obtained in such terrible circumstances, there should be no obligation to pay back. What are those circumstances? Where there's a leader of the country who may be lining his own pockets, or who may be actually just using the money to build a monument to himself or to engage in war. And the argument is the international legal world should not require the repayment of those debts. This has not been recognized in law, but it has circulated and it influenced a lot of discussion. And I wonder about something like that in the context, for example, of the mortgage disaster here, the mortgage debt disaster. Wouldn't you want to call some of that odious debt? So I explore some contrasts of that nature. And then I do talk about amnesties and pardons. And the development of amnesties have been around since ancient Athens. In fact, this whole notion of debt forgiveness every major civilization has used forgiveness of debt and forgiveness of crime. You've heard of the Jubilee from the Bible. There are similarly efforts to have a restart button, as it were, the Hammurabi's Code. Civilizations whose names we don't even remember used this kind of technique to have a restart when there was too much enslavement of people, too much criminal punishment, or too much debt. Well, amnesties have been around for a long time. We debate them in this country, for example, around the Dreamers or other immigration. But we've had some experiences where having amnesties have been very valuable in the country. For example, with regard to Vietnam-era protesters. And we also have pardons. I will confess, I started writing this book before the 2016 election, and after the election, I decided I needed a new section on what's not forgivable. And so I do have a discussion in the book about how President Trump has exercised the pardon power, and I think it's unforgivable how he's exercised the pardon power, and I'm glad to talk about that further. So that's what the book is about. I'd love to hear your comments, your thoughts. I am not a forgiving person, but I think the legal system should be more forgiving. Okay.
Hi, I'm Kevin Mulshine. I'm an attorney mediator. And I wondered, I want to look at your book, but I'm wondering, in your book, have you addressed settlement discussions or mediations as ways in which law can promote the giving of apologies?
Great. I'm so glad you raised that. And it sounds like from your work, you give lawyers a better name than some of us do. So that's great. Alternative dispute resolution across the spectrum, whether it's mediation or arbitration, can often, in my mind, try to deal with what otherwise is an unforgiving aspect of the legal system. And you point to something that I have found in my own work. I've done a lot of family law work, where actually acknowledging that there are long-term relationships here and the legal system can make things worse. Can we build into how we're solving this dispute a basis for a forward-looking dealing with those relationships so that they're more constructive? And so, yes, I do think that informal discussions, settlement, negotiations, having a setting where people actually hear from one another, what's really on your mind? What can I state back to you what the grievance is? You know, it's more on the continuum maybe of therapy, but it may be necessary to make a successful resolution. One of the major insights that I guess I learned from doing this work is a lot of law is too backward-looking and not enough forward-looking. And so how can we make the processes of dispute resolution look ahead to tomorrow, not just what happened in the past? And I agree with you. I think settlement can be very crucial for that.
Thank you.
Thank you. Hi.
Thank you. Fascinating
Thank
discussion. So I'm wondering if you thought about applying your theory at all to the concept of punitive damages and torts and how we see that as such an important public policy, but what you're really reflecting is sort of the opposite.
Oh, that's so interesting. So punitive damages certainly are a form of punishment, and it's kind of surprising because it's in the civil system and it's not supposed to be a punishment system. I do think that the original and ongoing idea is that sometimes the compensatory damages, the damages that are based on the actual monetary loss, are relatively small, particularly if it's against somebody who has a lot of money or a company with a lot of money. So to make them have the deterrent effect may require some more money. Then you deal with the question, but who should get that money? Should that extra amount of money go to the individual who brought the lawsuit, or maybe it'd be better spent going to a societal purpose? And I think that's often my view, is that I don't want to get rid of punitive damages. I just don't want the windfall to go to the one person who happened to bring the lawsuit. So I think that there are mechanisms for doing that. Exactly.
So I'm not coming at this from a legal perspective. I'm a mental health clinician, but I'm curious about how do you teach forgiveness when it's not in the forgiver's best interest? The school to prison pipeline is very profitable for certain sectors, and so what role does altruism play in the courts?
Oh boy, that's a really powerful and deep question.
Sorry.
No. I think that forgiveness is not often in the interests of many of the actors, and that's why we're in the world that we're in. I mean, just as an example, one reason that so many people end up in jail in this country is that they're poor and they can't pay fines and fees. And then the legal systems in many communities add more fines and fees that they're not able to pay. And so that self-interest, I think, is a big part of some of the situation that we find ourselves in. So, but you began your question by saying, how can we teach people? And I guess that's where I have my greatest hope. I think that we can actually teach people about how to give an apology that's a real apology, as opposed to the fake apologies that say, if anyone was injured, that's not an apology. And also how to forgive. I think that's something that you can be taught. I think that Brent Jean learned how to forgive. This is not something that just happened spontaneously. I know for a fact that for the family members who forgave Dylan Roof, the practice of forgiveness is something that they worked hard on. So I think that we can actually interpersonally and educationally work on some of those skills. When it comes to the systems, much harder. But there, I think developing some principles about when the techniques that are built into the system can be used, should be used, would be good. So I hope that's helpful. Thank you for the question.
I'm Jim Sandman. I'm
Hi,
a
Jim.
lawyer. How can American law become more forgiving when American society is so unforgiving?
Yeah.
You started by noting how unforgiving we are. And I'm thinking about a situation where the law permits forgiveness, but the public is repulsed when it's exercised.
Yeah.
I'm thinking of Gerald Ford's pardon of Richard Nixon. Many people think he lost the election of 1976 because he pardoned Nixon. Many people thought there was a quid pro quo there.
Yes. Yes.
I resign, you pardon me.
Yes.
So how can we make this work
Yeah.
in the United States?
So, which comes first? Do we have to have a more forgiving society before we can make the law more forgiving, or can we make the law more forgiving and that'll help develop a more forgiving society? I think we probably need to work on both. The example you give of the pardon of Ford is one that I have thought about a great deal. I was very struck to find out that until he died, President Ford kept in his wallet a quotation. I'm just looking for it. Here it is. President Gerald R. Ford was never one for second guessing, but for many years after leaving office in 1977, he carried in his wallet a scrap of a 1915 Supreme Court ruling that said, a pardon carries an imputation of guilt. An acceptance of a pardon is a confession of it. So in his case, people were so critical of his giving the pardon that he wanted to actually just remind himself, this does not wipe out the blame. The blame is there. I think that we have both tendencies. We're both resentful and unable to forgive, and also when forgiveness is given, we often are critical of the forgiveness. I think that in this particular instance, I'll just stick with Ford for a minute, time turns out to be incredibly powerful. So Bob Woodward was a big critic of the giving of that pardon. He actually was one of the reporters who tried to develop the theory there was a quid pro quo. Nixon said, if I step down, then you can be president, but you have to forgive me. We don't know to this day whether that's true. But it's interesting that not long ago, about a year ago, Bob Woodward said publicly he was wrong. At least when it came to whether this was a good thing, the pardon. He said the pardon turned out to be essential for America's ability to move on. I think that's right. So maybe one thing we need to do is study more these examples and see, at the moment you may think it's horrible, but it may be a very important activity. At the same time, I think one reason that, and rightfully so, people are very critical of granting of pardons or other kind of forgiveness is it looks like it's the opposite of law. Law is treating likes alike. It's about predictability. It's about accountability. And so I think that there is a real risk of undermining the law's even-handedness and predictability, which again is why I think we need to develop some criteria for when there should be forgiveness. Thank you. Yes.
Hi, thank you very much for your book and your presentation. About 30 years ago, my my father's youngest brother and his wife were killed in a very messy
I'm so sorry.
murder, like Sharon Tate murder in California. Both were in California. Now, give or take 30 years later, somebody's come up with a glitch in the original conviction,
Wow.
calling for a retrial. Well, that raises, this guy has been on death row, give or take 30 years, and a retrial, what can happen? I mean, it seems like it would need to be relying on forgiveness or something other than what the original trial would have been, what would have been involved.
Wow. I'm so sorry. I can't even imagine. One of my dearest friends was murdered a block from her home. And when people ask me, why do you write about what you write about? I think it has a lot to do with that. I don't know the particular details. I can say that I would predict that if there's a call for a retrial, there was probably a procedural error.
Yes, it was a procedural error. Some procedural issue.
Error. And I don't think that that's about forgiveness. That's about actually protecting the rule of law.
Yes, but but the trial itself, I'm talking about the trial itself and the jurors. How can that retrial not really involve forgiveness more than a legal issue?
Well, I think I will give that more thought, but I think typically a retrial is saying something was defective and now we have to do it again.
But
And
we're
it's
people.
Not, it's not because, you mean, should the jurors be forgiven for their procedural
How can
error?
you deal
I
with
see.
that retrial?
I see. Really interesting. But if the system actually is too tolerant of its own errors, then we don't have law anymore.
Hi, Professor.
Hi.
I'm wondering if there is any intersection of your principles and the theories of judiciability, particularly standing. So in order to, in essence, enter through the courthouse door and to invoke the legal system, you need to be a party. And to be a party, you have to have a harm and an injury and causation. We know that there are areas of our society that you can invoke the courts, such as with a political question. That's not judiciability. Doesn't invoke judiciability.
You might be thinking about
So
emoluments at this moment.
right.
Yes.
So I'm just wondering, are you envisioning some version of our legal system that is much more expansive than what we have now, that perhaps can address like soft harms or soft injuries, are hard and fast injuries that are so clear that you can get a prosecution going, you can get a civil suit going? Are you thinking of bleeding the lines out of your paradigm?
Well, it's an intriguing question. The legal doctrines you mentioned, justiciability, political question, those are all rules made up by federal judges for federal courts. Those are not rules in state courts. Those are rules that federal judges have created in order to have a smaller docket and to avoid hot issues. And that's within the discretion of the judiciary, even in the federal courts. But in the state courts, many of them don't have those rules at all. So I don't have to be the one who invents a wider aperture for law. I can say that one of the concepts or developments that my book is very compatible with is the notion of restorative justice. And restorative justice basically stems from a lot of traditional methods of dispute resolution, some new ones, some forms of settlement that say we need to understand that conflicts that may even look like they're between two people, if we really explore it, they often involve concentric circles of harm and blame and cause. And if we create settings where people can explain, here's how I was harmed, and develop a remedy that's specific for that situation, it may involve not just those two people, but a larger community. I am in favor of doing that in many more circumstances than we have. And yes, I believe that that can encompass many areas that right now would never get to court. It's interesting, here in D.C., the actual prosecutor for juvenile crime has turned all of the juvenile proceedings to restorative justice processes. And the rise of restorative justice in schools is, in this country, where this has its most purchase, to try to deal with the school-to-prison pipeline, among other things, and to build the capacity in the community, including from peers, to be able to understand we can solve these disputes in some way other than just putting one person as the cause. There may be larger processes, and also we might come up with more forward-looking solutions. So yes, thank you. Thank you.
Thank you so much.
Sure.
We're so happy we stumbled on this talk. We were just browsing here at Politics and Prose. So my two comments and questions are related to the topic of restorative justice and the efforts of restorative justice. Your talk makes me think of the recent Redemption Project by Van Jones on CNN, which we were following closely. We have a podcast called 1 in 4 that is about the criminal justice system. And in documenting the Redemption Project documents forgiveness, but I'm wondering, between victims and perpetrators in the U.S., how effective can these restorative justice efforts be when it comes to policies, affecting policies? Because like you said, one thing is between at the community level, individuals, and it's such a powerful series that he did, and he's such an incredible advocate for justice reform. Then, second sort of thought that comes to mind is Rwanda and the Gacaca courts.
Yes.
And that's a collective way to deal with a genocide, get beyond it. I mean, Rwanda is the size of Maryland with about 11 million people. So the likelihood that one is living next to a perpetrator or has been a victim of genocide is really high. So in a country like Rwanda, my question is, how can these efforts, especially if they're driven by a government that has a certain agenda?
Yes.
Yeah.
Two very, very good questions. Yes, I do think that it's more complicated to think about the kind of redemption and really moving exchanges of apology and forgiveness that we see between individuals when we then turn to policy. But let me give you a story that I think is somewhat hopeful. So there is a movement for criminal justice reform right now in this country, and it's broad-based, and it involves people of many different political views. And some people come at it for religious reasons, and some people because of their own life experience, and some people for economic reasons. Whatever the reasons, that movement has led to the election of new prosecutors in many parts of the country. We have a new one in Boston, and she was elected really with this view, we are too punitive, do something about it. She has adopted a policy, she's been quite explicit about it. She is not using her prosecutorial discretion to pursue low-level drug offenses. And she's very public. That's a policy. She's being eviscerated publicly for doing it. So it goes back to Jim Sandman's question. People have ambivalent feelings about this, or there are people with different views. But there's an example of a policy change. And that one is a policy change that reflects a democratic decision. The Gacaca courts, so everybody knows about the horrific genocide in Rwanda. In order to deal with a situation in which it wasn't even just neighbors, it was family members who picked up the machetes and killed someone that they knew and loved. I mean, it just unspeakable violence, massive numbers, mobilized by hatred that itself was spewed on radio to serve a government policy. I mean, how do you unwind from this? The government's policy decision was to try to deploy a traditional dispute resolution technique that had been developed to deal with matters like stealing cattle, and move it over to genocide. And that was one problem. Another problem was so many people who were experts in the Gacaca process were killed. So it was to recruit people who'd never even engaged in this informal dispute resolution. Gacaca means sitting in the grass in the hills. Nonetheless, simultaneous with the International Criminal Court proceeding with prosecutions and domestic criminal courts, the Gacaca courts proceeded. And, there's mixed stories about what was helpful and what wasn't. Some stories are the people were coerced into saying, I forgive you. Sometimes people who were involved in the same massacre, some ended up in the International Criminal Court and some ended up in the Gacaca, and some were incarcerated and some weren't. A big surprise to the government was the Gacaca process actually led to many, many more people going to prison, and the prisons were then overcrowded. So it's a mixed story, but I admire the effort to invent a response to a situation for which the usual criminal justice system was not actually capable. Yes.
I'd like to focus on this issue which you've been talking about, which is sometimes there are larger policy reasons. And I mean, a great example of that would be South Africa under Nelson Mandela, or even the example we were talking about a few moments ago with Gerald Ford pardoning Richard Nixon. It wasn't necessarily because he deserved compassion.
Absolutely.
It was because there was a greater good of trying to heal the wounds in the country and be a unifying force. And it seems to me those are very different types of actions than actions that involve individualized compassion of a victim to somebody who's done something horrible to them
Yes.
or their families, or something that in the more normally used version of the term forgiveness would be seen as forgiveness, as opposed to those acts of pardon that really are about larger societal policy issues. And I'd like you to sort of speak
Great.
about the spectrum of that
Great.
and how you analyze different types of actions differently.
Great. That's really analytically very sharp and a very good insight. One of the fascinating topics that I stumbled onto in my research was work studying large apes. It turns out large apes engage in a lot of violent activity, and then they have reconciliation rituals. Remarkable, right? The reconciliation rituals typically involve mutual grooming. I'm not suggesting that for human beings. But that combined with the historical evidence, whether it's ancient Athens or it's Hammurabi's Code or it's the Old Testament, that there have been the creation of these societal-wide mechanisms for forgiveness along with cultivating an individual capacity. That's what drew me to this interest. And yet, I agree with you, there are very different dimensions of the interpersonal and the society-wide. Having said that, it's now like the Mayo Clinic health letter says it's healthy to forgive. There's now scientific evidence that if you don't forgive personally, the grudge affects your blood pressure and so forth. You mentioned Nelson Mandela. Nelson Mandela, who offered a model of forgiveness not only to his nation but to the world, he said, resentment is like drinking a poison and hoping it will kill your enemies. So even in that instance, there's this acknowledgement that the letting go of a justified resentment has benefits to the one who forgives, not just, now I'm responding to someone who has shown contrition and I am now, by the grace of whatever, offering them forgiveness. Every religion and every philosophy has developed something like a forgiveness practice, but they're really different. Some of them imagine a script where somebody asks for forgiveness and as penance says, here's what I will do, here are the actions going forward. Others actually elevate forgiving without any action on the part of the other, with a view that that's what divine forgiveness is. So you're right to point to this variety, but the variety is there even in the core notion of a religious concept of forgiveness. People disagree about whether it is in exchange for some conduct on the part of the other, as opposed to, is it something that's going to relieve the one who's been victimized? And yet a third is it good for us all? Is it good for humanity? So I don't think that it falls into neat categories. I think that this capacity, which turns out not just to be human, turns out to be large mammals. This is a capacity about how do we live with each other.
Thank you.
Sure.
Hi.
Hi.
My name is Tim Nicholson. I'm co-host and partner of Bea here.
Great.
I have a question that deals more with this idea of apathy. Apathy. Because Ferguson is a really good example. And when there was the Department of Justice, Eric Holder, I think, led this investigation. And they did a fairly deep dive about the demographic changes and the election of a mayor, the appointment of I believe a finance person, some of the revenue that was tied into the broken window policing and citations and all that. But without the proper context, and I would go as far as saying that I don't think very many people probably picked up this document and read it. I read through it. That they're left with their own biases, which, of course, given who's telling the narrative, creates a sense of like someone's getting what they deserve, or this neighborhood or this person is getting what they deserve. The police, on the other hand, are also undergoing a level of stress and misunderstanding, which is difficult for me to say in some cases. But given that pressure to maintain these revenue streams, put themselves in a position where they have to do so in order to assure themselves some promotion within the department. So there's many different examples like this. Misdemeanor Land, the book that came out not that long
Issa
ago.
Kohler-Hausman.
Oh, it was great.
It's a great book.
It was very revealing.
Yeah.
So what we're attempting to do is elevate these conversations. I know the 1619 Project is trying to give some context as to why things are the way they are now, and showing this tie between slavery and institutions that are still plaguing these communities today. But my biggest fear is this idea of apathy. If we can't elevate the narrative, the proper context to a level that more people are hearing, and I think we are punching through slowly now, then there is a sense of apathy, and how do we deal with that? Because I am one of these believers that I think if we change the legislation, some of the other things will follow. I hate this word tolerance, but without the civil rights law, would people have been as tolerant as quickly as they have been without it?
Well, this is a big question. Brian Stevenson, the author of the really important book, Just Mercy, is a friend of mine, former student, and he said, I can win these cases in the Supreme Court, but I cannot change the causes until we change the narrative. And that's why he has worked so hard to create the museum, the Lynching Museum, and the memorials in Montgomery, Alabama. And I agree with him, and I believe that changing the narrative, your point about context, is absolutely essential. I worry about apathy. I'll tell you, I worry even more about reverse resentments. I worry that when we have discussions about reparations for slavery, that then there's another group of people who say, what about me, or why should they? And again, I don't know what more to do other than, yes, much more work on history and context, but also work on the continuum, if you will, between the individual and the society. And we will be better off as individuals if we develop these capacities, as well as the society will be better off. We got to work from the inside out and the outside in, I think. Misdemeanor Land is a very important book you mentioned by a young professor at Yale Law School, which argues, just empirically, that the vast number of people who are incarcerated in jails in this country, jails are not prisons, but in jails, it's pretrial. And it's pretrial because they can't pay. And we have a Supreme Court opinion saying that we do not have debtors' prison. So how could this be? The Department of Justice report that was the result of the Ferguson investigation exposed not just a minor problem, a systemic problem built in, that these institutions, the policing, the parole, the courts, across that whole region in Missouri are completely dependent on the fines and fees that then poor people can't pay, and then they're incarcerated. This is unconscionable. And what I am happy to say is that more than a few people read the report, and there's litigation going on all over the country, as you know, and it's being successful, exposing these practices as violating the United States Constitution, state constitutions, and I think it's beginning to make a change. California has changed its cash bail system. We're beginning to see some changes. My worry is the next frontier is algorithmic decision making. And so it's going to be behind the screen of a pseudo objective analysis who's getting released and who's not getting released. Well, how did you train the algorithm? You trained it on data based on the current system, which itself is filled with racialized decisions about who gets arrested and who doesn't. So that's the next frontier.
Thank you.
Thank you.
Oh, I'm so small. Oh, thank you very much. Hi, my name is Charlotte Bestin, and I am a high school student.
Wonderful.
And you spoke about student debt.
Yes.
And this leads me to my next question. How often does student debt deter students from the pursuit of higher education? And how has this gap in education in certain areas affected the United States political scene as a whole?
Oh, what a good question. Wow. So I am so old, and I went to a public university. So the combination means that people could go to university when I went and pay for tuition based on their summer earnings. That is not true anymore in most parts of the country. And that is not true in public institutions as well as private ones. And yes, that is deterring people from pursuing higher education. Moreover, since the difficulty of translating the higher education into a job that is well paying has become rarely pronounced with the changes in the economy, many people are saying it's not even worth it to go. If I have a degree in English, what am I going to be able to do when I graduate? And so you have an explosion on campuses across the country, people studying computer science, which is great. I have nothing against computer science, but the world will not succeed if we only have computer scientists. I think that this is a crisis, and one thing that is happening is that we're seeing it enter politics. And I think it's not by accident that the leading candidates for the Democratic nomination for president are talking about student debt and ways to finance higher education. I personally believe we should have a tithing system that takes the form of people should have no tuition up front, and they should actually have a commitment to pay back based on a percentage of their income, whatever their income may be. I think that would be better. We're going to have a little of a transition problem to get there, but I think conceptually that makes more sense than what we currently have. Thank you.
These have been really good questions. I'm afraid mine may not stand up to the thing because it's kind of narrow in focus. But other than tradition, in your mind, is there a good reason for the president to have the power of pardon?
Oh, I think that's an excellent question.
I mean, that part of the answer may have been in the gentleman's earlier question about sort of the policy role of the pardon as opposed to the individual. But on the other hand,
it's great.
The opportunity for abuse
misuse
of the
is we're watching before our very eyes. So the pardon as a power came to the United States borrowed directly from England. And it was a royal prerogative. And indeed, the King's Court, the Court of Equity, expanded that idea beyond individual pardon in criminal cases to a notion that the King's Courts could just do justice regardless what the rules were. And really, that reflects an idea of an omnipotent ruler, which seems a little inconsistent with a democracy. So the only adjustment in the United States, at least when it comes to the president's pardon power, the governors also have pardons powers that vary across the states, is the only adjustments are twofold. One, the Constitution indicates that the pardon power of the president is absolute except, quote, in cases of impeachment. Now, that's a really interesting exception. That suggests that the framers understood that there should be an area where the president does not have this power, and that that area is where the process is a political one. And yes, I do believe that means that if there's an impeachment of the president, he cannot pardon himself. What's not clear is that because the framers knew how to say that, but they didn't say he can't pardon himself from a criminal matter, does that mean he's allowed to pardon himself from a criminal matter? That's just not clear, and it's troubling. The other area where the pardon power, at least for the president, is different in the United States than it was in England is it's been at least rationalized on the grounds that we have checks and balances across the branches of government. The president nominates judges, the judges are confirmed by the Senate. But what if the judges do something that's wrong? So the pardon power was a check and balance against the judiciary by an elected official. That was the idea. At least it's been justified. What's fascinating to me is I've learned that in some states in the United States, but even more in some countries that have more modern constitutions than we do, the idea of giving this absolute power, this extraordinary power to one person has been rejected. So in South Africa, there's judicial review of pardons. There are some countries that have a commission. There's a group. There's some states that have commissions. I actually saw last night someone from the Department of Justice who's in the division that used to actually process pardons. And I said, what's going on these days? He said, we don't really see a point since it's not going to be paid any attention by this president. This president is using the pardon power, I think, in the most unacceptable way as a kind of personal privilege, but also for his own political advantage. I think that we need criteria for judging pardons, and I offer two. One is pardon should not be used in a case of corruption. And one kind of corruption is self-dealing. The classic case of self-dealing is to pardon yourself. And another case of self-dealing is to pardon people who have been good to you. And I would put in this category, actually, President Clinton's pardon of Mark Rich. This is someone who was a campaign contributor and who actually gave gifts to the Clintons. I think that was an inappropriate act, and he knew it because he did it the last day of his presidency. Right. So corruption, in my mind, is one instance where we should not allow the pardon. And while we don't legally have a basis for limiting the president's pardon power, we politically have a way to limit the president's pardon power. And the other area where I think we should develop some norms about the use of the pardon power is we have to, of course, worry that the grant of a pardon may encourage people to disobey the law. And I think that we should be distinguishing those kinds of disobedience that we can live with and those kinds that we can't. And therefore, and in the book I do this, I just compare President Trump's pardon of Sheriff Arpaio, who's pardoned not only because he was found by a court to have systematically violated the civil rights of classes of people in incarcerating them and detaining them in inhuman circumstances. He was then further found in contempt of court for continuing to engage in those practices. And it is that contempt that was pardoned. That seems to me completely unacceptable. That's saying the rule of law is irrelevant. That is saying that disobedience of a court order is okay. I just disagree with that. I compare that with, for example, Dr. Martin Luther King. And Dr. Martin Luther King disobeyed the law, but he disobeyed the law, it seemed to me, with good reason, and we should have pardoned him rather than what the Supreme Court of the United States did, which is it upheld his contempt citation for marching in Birmingham in violation of a court order. So I think we should develop some criteria. And there's some pardons that I think are acceptable and good, even if they encourage law breaking, and others that I think are unacceptable. So thank you for that.
Hello.
Hello.
Hi. I wanted to go back to the previous question about higher education and your interesting suggestion about tithing. And I wonder what you would think about extending the principle of tithing to the institutions of higher education, so that every university or college would pay an amount into a collective scholarship fund proportional to its wealth. So wealthy institutions like Harvard would pay a lot of money to support the education of students at all universities, not just at Harvard.
So I no longer have a position of authority at Harvard, and I'm freer to speak. I guess I think that that's a very promising idea, but I wouldn't limit it just to the institutions of higher education. I think there are other sources of wealth in the country, and there are other sources of value, and they should all contribute. And I think that if we were a sane society, we would subsidize the education of the next generation and make that investment. And that should be distributed across the society. not just those pockets of wealth that may be endowments of a few wealthy institutions. But I like the idea of a collective response. And in many ways, that's an approach that permeates my book, that if we think about restorative justice, we think about bankruptcy, we think about collective amnesties for immigration violations, it's to recognize that what often seems like it's an interpersonal or one person's problem, it's actually systemic. And we need solutions that are systemic. So thank you. I think that's it. Thank you. Thank you. Thank you.